This is the part 2 follow-up on the series on judicial release. So at this point, we know that you cannot file a motion for judicial release if you're serving mandatory time, and you know that there are eligibility requirements for judicial release that's based on the length of your sentence. So what happens after you file the motion for judicial release? So the court has time constraints after it receives the motion. So the court can deny the petition, but once your petition is received, the court has to make a ruling on it within 60 days if it's going to deny the petition. If it's going to hold a hearing on the petition, then the hearing has to be held not less than 30 days or more than 60 days after it receives the petition. And the reason for that is that, of course, there's victim notification. So once you file that motion for judicial release, the state has to notify the victim if the court is actually going to hold a hearing on it. So again, if the court is going to not hold a hearing, then the court can deny that petition within 60 days. If the court is going to hold a hearing, that hearing must be held not less than 30 days or more than 60 days after the court receives your petition. So as with everything, there are exceptions to the rule, and the exception in this case is that the court can extend holding the hearing for up to 6 months. After the hearing is held, if it's granted, you will be on community control. So you'll be on community control for whatever the terms could have been if you were initially granted community control. And that means you will be under the supervision of the Department of Probation. So if it's granted, Department of Probation for as long and of whatever conditions could have been if you were originally basically given community control. And if it's denied, you will get that decision within 60 days. Now you know.